Okay, welcome back everybody. I hope you had a relaxing last week. You just had the midterm to do and I know a number of you did it very early and that's great, and you were able to hopefully concentrate on some other courses, get a little rest, get recharged. We're halfway through the semester. I know we have no spring break and we're doing the straight 15 weeks, but I thought everybody could use just a little bit of a breather, so I hope you enjoyed that. We did have the midterm. Let's talk a little bit about that midterm, and then we'll talk about administrative laws and some other stuff this week. Probably a mixture of some stuff that I think you might find interesting. So overall, the midterm scores were very good, exceptionally so, quite frankly. But I would like to make sure everybody understands that D2L creates a lot of records. I can see quite a few things when it comes to these quizzes, especially. Please don't forget what I do for a living. I can see when someone has a 30-question quiz and they finish it in less time than it would take to actually read the questions. That I would call a red flag. So I just caution everybody, be very careful. I invite everybody to go reread the syllabus section on academic integrity if you have any questions. But just know that I am watching very carefully on quizzes, discussions, papers, and using the tools available. So that's my warning for the week, and we will move on from there. So what are we going to do this week? So I'd like to continue our discussion a little bit on privacy, not so much on the privacy, the privacy administrative laws. I know that was a little dry for some of you, but they're really important, especially the GDPR stuff and the California privacy laws that are going to be the law of the land at some point. Everybody seems to be adopting them. But I'd like to talk about the privacy side that we kind of ended with, which was the employee expectations angle of privacy, because there's some things in there that can definitely jam you up as a security manager, and also things that you generally should know as an employee. So we'll look at the workplace actions related to the administrative laws and some court decisions. And then we'll finish up. We'll kind of about 2/3 of the way through, we'll just switch gears real fast and go into some very specific administrative laws that impact security managers. I've got two of them in that I just want to make you aware of, but they give you a flavor of the types of things when I'm talking about administrative laws that really do impact security managers, and you really need to understand the ones that are general and the ones that will impact specific industries that you may work in. So just to kind of recap where we left off, we were talking about employee privacy and what's really acceptable from an employer. How far can an employer go, and what expectations of privacy are codified in the law that employees enjoy and you must respect. There's a lot of new technology. I mean, we can't turn around without a new technology hitting us in the head these days. And I'm not so sure that every new technology considers the privacy aspects and the privacy, not just the privacy of your data in this regard, but privacy in general. And just because something is available doesn't mean it's right. And so as a security manager, some of the things you'll make decisions on, excuse me, as to whether they're okay or not okay. And there are a number of red flag court cases on privacy in the workplace that you might want to just be aware of, not just the laws, but also some of the common law decisions that would impact how you as either an investigator or a security professional might act and might make some decisions. So we'll talk about those the first 30 minutes or so, and then we'll move on from there. So let's talk about hidden video. So we all know, any place you go, you're on camera, right? I mean, I think there's an expectation of that now. I don't know that the statement I just made is true, and I think actually it's overstated. There are many places where you believe you would be on video and you're really not, right? If you walk around any big city, you'll probably be picked up by a video camera inside of a building as you walk by, but not everybody has external cameras, and not every police department uses them in every part of a city. There's kind of a expectation that that's the case, and it really isn't. But they are certainly a lot more in use than they were 15 years ago, 10 years ago, 5 years ago. But when we talk about hidden video, covert video, it's a whole nother ballgame, and you've got to be very careful with that in the workplace because there are some reasonable expectations of privacy. So it really, when you think of hidden videos, think of the nanny cam, right? The nanny cam was a product that was a small video recorder built into a teddy bear that parents would put in the bedroom of their children so that they could make sure that live-in nannies and babysitters were not abusing their children. They could play back the video if something was amiss. They could play back the video if something came up missing. So the nanny cam became a very popular item in homes, especially of those who were more affluent and could afford such things, right? And had live-in help with their children especially. Now you're in your own home, so it's generally legal to do that. But there are areas, even in your own home, where you can't videotape, right? Bathrooms, there's a reasonable expectation in the bathroom that you have privacy, right? Bedrooms are a little different, especially if you have a live-in. So if you have a live-in nanny, let's just say for your children, you could not put a nanny cam in that person's live-in quarters. That would be not allowed. But you could put a cam, and again, the nanny cam in the teddy bear went into the child's bedroom because the nanny that you're trying to take the pictures of had no reasonable expectation of privacy, and the child, being a minor, has no reasonable expectation of privacy from their parents who own the home. So therefore, that would be allowed, but it would not necessarily be allowed in the living quarters of a nanny or an au pair. Now, video is really progressing where a lot more video camera manufacturers are adding audio. And I get approached every day by someone who is selling cameras with audio built in. And covert audio is really never a good idea without a warrant. There are one-party versus two-party states. And a two-party state requires that both parties understand that they're being audio recorded. Conversely, in a one-party state, only one party needs to know. Pennsylvania, where you are, is a two-party state for private conversations. So it's a little bit different. You can tape a police officer without them knowing it while they are on a traffic stop, stopping you in traffic, right, or questioning you, because that is not considered a private conversation. However, two people talking in the park, even though they're out in the public, if they're talking with each other, you couldn't record, and one of them couldn't record the other because it's considered a private communication. So, I'll come back and say this again, but audio recording in the workplace, why would you ever want to do it? I mean, there's just no good that can come of it. So my advice to you is to really think long and hard if you ever want to do it. But hidden cams in the workplace, they're allowed, but there needs to be a notification somewhere. Either signage that says that video surveillance is used in this facility, something in the employee handbook that says overt and covert video may be in use for the protection of our employees and our property. You really should have some kind of notification. The employee handbook is the best place to put that. But I would include in that covert video, because you may have a case where you want to use a hidden camera for a very specific, serious incident. Ongoing thefts of files, information, right? You may want to use covert video. You get permission, perhaps from your legal department, whatever your company policy is, but you may be allowed to use it. But you'd want to make sure that all employees understood that that is a possibility. So the employee handbook is a place to put that. Now, in union workplaces, you look at the collective bargaining agreement. That's what a CBA is, collective bargaining agreement. It's often an item in the agreement as to whether or not you may use covert video in the workplace. There could be a union agreement that says you will not use hidden cameras in any work areas where employees covered under the collective bargaining agreement, union employees, will work. Some workplaces have it, some don't. But you're going to want to understand, if you have a union environment, what the CBA says about covert video, if it says anything, to make sure you don't run afoul of it. And then getting back to repeat myself a third time, audio recording in the workplace, seriously, just let it go. It's not worth the juice is not worth the squeeze on that. It's just too hard to prove the provenance of the audio and to show that the other persons who may have been recorded were aware of the recording. It's one of the newest things that's popping up in workplaces all over. I mean, it's been around for quite some time, obviously, though, is GPS tracking. And GPS tracking has been around forever. Obviously, we use it with our mapping programs, to get from point A to point B. I think I would follow my GPS. If it said take a left turn into lake, I'd be swimming somewhere because I just follow it wherever it tells me to go. But GPS tracking for work purposes is becoming more and more an issue. And it's being used to understand sales and sales calls, right? So if you have a mobile sales force who is supposed to be going out and stopping at convenience stores, perhaps to show people the product line that you have, because you sell batteries and they're at the end cap at the convenience store, right? And you want to show them these new batteries that you have available, and they're cheaper than the ones they're using, better than ever ready. You want to show it to them. You may want to use GPS tracking to show how many times did somebody stop at a convenience store to detail it, and what are the sales that's associated with that. Is that the best way? Is it going in and talking to the manager, or is it sending them literature, which will be cheaper? So it's a metric kind of thing. Now, geofencing is used if you have a territory and you want to keep somebody in that territory. Certainly for trucks that are moving precious cargo from one place to another, you put a geofence, you put a route on them, and they stay on that route. I have more than once, and I think you've heard me say this, had to track down truck drivers who had gone off the route because they were going to visit a friend while they were on the road, and went off the route, and the geofence alarmed and told us they were off track, and we had to go and get them back on track. But geofencing can also be used for emergency notification systems. If you have a big global employee base, you may want to have a geofence set up if you have an emergency. So if there was a bombing in Paris downtown, my company can set up a geofence around the bombing area by, say, 3 miles, 4 miles, and then send out a signal to those employees who have opted in to emergency notifications, and specifically send them a note saying, do not go toward this building. There was a bombing in that building. And you're close enough that you might just wander for some reason to that place, and you want to get away from that place. So we have an opt-in, which is obviously permissible, but some companies may want to have an emergency notification system that's not opt-in. We want to know where you are all the time so we can make sure that you are safe. So they can be connected to that. Safe routes for cargo, kind of like I said with the geofencing, that's not necessarily safe routes as much as it is the most efficient route sometimes, but also safe routes. If you know where a truck is and you know that there's a tornado sighting 10 miles ahead and you're a trucking company, you may use the GPS to say, call that truck driver and tell him to stop, seek shelter, turn around, use a different route, whatever. Access control systems via location are actually becoming a thing, and I don't care for them much, but basically if you have an access card to get into a building and you also have your cell phone with you, your card will only work if your cell phone is also within the grid square of that facility you're trying to access. It keeps it from, if you lose your card and you are in 10 miles away and your card's trying to be used to get in a building, it says, no, I need both the GPS location of the telephone that this person has, and it matches up with their badge so that I know that they are at least there in that general area. And then companies are using it more and more for efficiency monitoring for deliveries. So, the folks at Amazon certainly don't want to have 3 or 4 Amazon drivers running into each other in the same neighborhoods. And so using GPS tracking, they can monitor that to say, how come everybody's congregated over here? Did somebody get the delivery spread wrong, where we didn't put, we overlapped neighborhoods too much and we've got too many people in one place. We could have put all of this on one truck and saved amount of time and money in our deliveries. So it's being used for all those purposes, but does it need to be is the question. So as you said, you can use GPS for all those things, but who owns the vehicle? Is the vehicle that you're putting the GPS on, does it belong to the individual? Is it their personal vehicle? Is it leased by the company? Is it leased by the individual and the company reimburses them for that lease? The ownership makes a difference. And you'll see that in a couple of court cases. Geofencing. Do you need it after hours? If a person is not traveling, if I travel somewhere, could somebody tie in my travel record, because I do have to book my travel with a company travel agent, and that's to get the best prices on tickets. So let's just say I'm going to Dublin. I go to Dublin fairly often, not every year, but most years I'm somewhere in Ireland, right? When I book a ticket and they know I'm going to be between, say, June 1st and June 15th, I'll be in Dublin, then could we not turn on my geofencing in Ireland during those 2 weeks? certainly that could be arranged. You don't necessarily need to have it on all the time. And after hours, again, is it really the company's business where I might be? It's a matter of necessity. Just because you can doesn't mean you should. Can we assume location on emergency notification systems? Again, when I'm traveling. Safe routes for cargo, right? What's the process for non-compliance? If we're tracking people with cargo, what do we do if they go off the route? If we don't have a process for that, then what are we really using this data for? Again, the access control via location, it just doesn't make any sense. If somebody's going to steal my access card, they can steal my phone too, and they'll be in the right place, right? And then this monitoring for deliveries, the example of 4 or 5 Amazon trucks in the same neighborhood. If you look at this at a high enough level, I don't need to know who those drivers are. I just need to know that 4 or 5 trucks are, overlapping way too much, and we're running an efficient operation, and address the systemic issue of, balancing out the loads between different areas. I don't need to know who those drivers are. So could it be anonymous? And again, some of these GPS tracking programs are good and they have a use. My point being is that you don't always necessarily need to use them or need to know who exactly is associated with them. You need to prove a need for that if you're going to use these things. So on GPS tracking, I found a number of cases, and I found a pattern actually. I just have 4 of them here because these 4 prove the pattern, I think. But I literally went through dozens of decisions, and the pattern was definitely there. The first one is Tubbs versus Wind Transport. It's a 2007 case. And Tubbs was employed by Wind Transport, and Wind Transport put GPS on his vehicle without his knowledge. And Tubbs sued Wind Transport, saying they invaded in his privacy because he was not aware that there was GPS on the vehicle. The decision was very swift. It was very clear. The court said, no, Wind Transport owns the vehicle. Wind Transport has a vested interest in knowing where that vehicle is at any particular time as the owner, and Tubbs has no standing. We're not invading your privacy if we're tracking our own vehicle. So GPS tracking on a company vehicle is certainly allowed. It would have been nice, quite frankly, if they told Tubbs that. Maybe whatever he did that probably got him into trouble and brought the case forward wouldn't have happened had he known it was there. But nonetheless, it is perfectly legal for a owner of a vehicle to track their vehicle, and a company can be the owner or leaser of that vehicle. Now, in U.S. v. Jones is a police case where Jones was a suspected drug trafficker, and the police put a GPS tracker on his car, and they used evidence from that GPS tracker to convict him. And the court found that that violated Jones' Fourth Amendment rights to search and seizure, and he was released from prison. He was totally exonerated. Now, let's think about that. A search. Is a GPS really a search? When I think of a search, I think of a search of records. I think of a search of going through your property, going through your purse and your suitcase and, your house, that type of search. With a GPS, you were receiving information, but you really weren't putting your hands on anything. But still, the court found that without a warrant, this was an invasion of the privacy of Mr. Jones by the state, which is covered under the Fourth Amendment to the Constitution, and therefore Jones was released. So we have the private owner being able to track a vehicle. We have the police needing a warrant in order to track a vehicle that belongs to someone else. Now, in Cunningham v. the New York Department of Labor 2013, Cunningham was a director I think it was organizational development, if I'm not mistaken, with the New York Department of Labor, New York State Department of Labor. And the Department of Labor tracked his personal vehicle, including 2 weeks while he was on vacation out of New York State. He was in Massachusetts for 2 weeks of the tracking time. And they used that information to prove that he was falsifying time records as to where he was when he was supposed to be keeping track of his whereabouts and his work for the state. Cunningham sued, and the court found that indeed the employer in this case, because they were using it to prove or disprove claims made by Cunningham on his time records, the court found that the state was allowed to use the GPS records, and Cunningham was terminated from his state employment. Now, in U.S. v. Katzen from 2013, Katzen brothers were basically suspected of a chain of robberies, and the police put a GPS on their tracker on their vehicle. And again, the charges were ultimately dropped against them because the court decided this was a Fourth Amendment violation on the part of the police. I think what we learned from this, and this was clear in the cases that I looked at, and I guess I have to say it's somewhat anecdotal, but for our conversations, I will say that the courts find the use of GPS much more palatable when it's done by an employer to track an employee than when it's done by the police to track a criminal, and generally don't require a warrant for an employer to track an employee with a GPS. Now, that should not give you carte blanche as a security manager to go out and put GPS on people's cars. Again, if you don't have to, why would you? And we have security managers that don't use that philosophy. They don't think about the fact that they don't need to do something. Why would they do it? But in general, it seems that the courts have decided that a GPS is indeed something that can be used to invade the privacy of someone, and that a search warrant would be necessary to put a GPS on a criminal's car, but not necessarily on that of an employee to track and see what they are doing, especially while on company time. Everybody's favorite subject, drug testing. So drug testing in the workplace, I will say that with limited exception has slowed considerably compared to the rate of random and even with cause drug screens that were handed out maybe just 10 years ago. I've been in the workforce for a long time, and I've been in security sensitive positions for a very long time, and been in positions, military positions and positions where I had to carry a firearm. You were sent for a drug screen a lot, right? We had a weekly random drug screen at one facility where I worked, where there was a lot of controlled substances, and weekly they would pull a number from 1 to 10, or 1 to 10, 10 being 0, right? So 0, 1, 2, 3, 4, 5, 6, 7, 8, 9, and if your social security number ended in that number they pulled, you went for a drug test. It was that type of random drug test, and I will tell you that my social security number ends in the number 0, and 0 was a favorite number to pull because I felt like I was in there every week. In 1988, the Drug-Free Workplace Act was passed, and people hear that and they say the Drug-Free Workplace Act, it must mean that employers can give drug tests, right? They just associate it with the title, and the titles of these acts sometimes have nothing to do really with what they are. The Drug-Free Workplace Act applies only to government contractors and grantees. So grantee is somebody on a government grant, a federal government grant, capital G government, right? So a university that takes government money to do research, direct government money, say from the Department of Energy, would need to make sure that employees that are doing that grant work, direct grant work, understand that they cannot use drugs while they are working the project, right? And they need to have a plan for testing and drug prevention. And the act is pretty specific about what they need to do, but the big thing I want you to take away is that it applies to government contractors and grantees only. And with the grantees, it really doesn't cover grantee individuals. So if I go and get a government grant, I apply, there's tons of government grants for research. Let's just say I want to do a research project and it's going to, cost me $5 or $10,000. I would go out and look for government grants that might support my research, apply for the grant, and if I get it, I get the money and I can do my research. I'm not even leaving my home. I'm doing it from my home, right? It covers my costs of research materials and internet access and, books I may need to buy, those kinds of things. I'd be an individual grantee. I wouldn't be covered then under the Drug-Free Workplace Act of 1988. Only government contractors and grantees that are part of organizations. So, again, this is the big thing about the Drug-Free Workplace Act is it only applies to the government. Now, when we get into private employers, we've got protection type acts. The Americans with Disabilities Act says that employers can't fire, refuse to hire, or refuse to promote someone simply because they have a history of substance abuse, nor can they do any of those things simply because somebody's enrolled in a drug or alcohol rehabilitation program. So the private sector, the acts tend to protect someone with a drug problem, where the government sector tends to frown upon it. I'm not sure why that is, and we saw that same kind of pattern, right, with the GPS, right? It frowned on the government use of things and gave more leeway to private employers and private persons, and we see that same thing with the American with Disabilities Act, where it prohibits the employer from discriminating against the employee because of a history of substance abuse or the fact that they're in a drug rehabilitation program. But there's more. When I said, and there's more, I felt like the guy said, but wait, there's more, right? There's the Family Medical Leave Act of 1993. And some of you may be familiar with this act. And basically what it says is that an employer must grant up to 12 weeks of leave to anyone who is addressing medical issues once those issues are verified by a medical authority. So it was written in the spirit of, I think, someone who gets cancer, right? You get diagnosed with cancer, you need treatment, you go for your treatment, and 12 weeks. I'm not sure what the magic number is there, but let's just say it. You go for chemo and you come out and you're great, and 10 weeks later you're ready to come back to work, right? You can still be being treated, but you're ready to come back to work. The company must hold your position for that long. If you've applied for family medical leave through the proper channel and you have a doctor's approval to do so, a company must honor that and must give you that leave. They don't have to pay you. Many companies do. Mine does, but many companies don't. They don't have to pay you, but they must protect your job for that medical reason if you filed for that leave and you've proven you can get it. It applies to family members' leave conditions too, by the way, and it can be intermittent. So I had an employee who got kidney stones quite often. I'm not sure it was hereditary or dietary or what, but he would get kidney stones. And he had Family Medical Leave Act for kidney stones. So he would call me on a Wednesday night and say, boss, man, I got it bad. And these attacks would last him, 10, 12 hours. I knew he wasn't going to sleep. These things are quite painful from what I understand. And so he would take the next day off. And that 12 weeks is, essentially 60 days of time off for these ailments. And it can be renewed each year. I'm not trying to get anybody to go and do that so they can get extra time off, but it applies to most workplaces and full-time employees. But it also applies to treatment for substance abuse. So now not only are private employers, are employees protected from discrimination on hiring, promoting, based on their past drug use or their current enrollment in drug treatment or alcohol treatment programs, but they can request time off from the workplace to go to that treatment, and the employer must honor that. The National Labor Relations Act of 1935, and as amended, talks about drug testing, and for union employees, it must be an agreed upon condition in the collective bargaining agreement. And don't assume that it's there. The professors at Slippery Rock are part of a union, and I looked at our CBA. I saw nothing on drug testing. And I think it's been taken out of many union contracts as a negotiation item. It's put in by a company, and then when they need to make a concession, they take it out, right? You put in things that you can drop later, so you can get a little bit of leverage in the bargaining agreement. But in a union environment, I would be hard-pressed to find too many union agreements that agree to drug testing for the workplace. What does all this mean? It means that if you have someone that is suspected of being under the influence of drugs in the workplace, you have a safety issue, but you may not have a security issue nor a legal issue, and you need to be very careful about how you proceed. I would certainly not be firing somebody because you suspected that they were under the influence of drugs, right? You need to understand your collective bargaining agreements. You need to understand whether or not they are on the Family Medical Leave Act under treatment. You can't know that, but your occupational health people can. But I guess as a security manager, you don't want to make a snap decision and say, oh, this person's under the influence of drugs, I need to get them out of here, because they are very protected in the workplace, unless they are a government contractor, and even then you'd still need certain proofs. So drug testing in the workplace is something that's kind of going the wayside simply because of those 4 acts and how they interact with each other. So another big one, social media monitoring. Why do companies even want to bother monitoring somebody's Facebook, Twitter, whatever, right? Instagram, whatever other social media, and there are tons of social medias. Those are the big ones that everybody knows. But social media. Well, Reddit obviously is another one that's come to more light as it's getting ready to go public. But social media can be simply a blog or a chat room, dedicated to people who collect toy trains. It's still social media, and companies can monitor those to make sure that their reputation is not being damaged by things that are said, especially by their own employees. They can look for anti-competition and client stealing. So if I worked for company A and I now want to go out on my own, I may want to steal some of company A's clients, take them for my own to start up my business. They can watch for that type of interaction between people. Advertising to do services that you do for the company to direct clients. Certainly, they can look for proprietary information that you may post in social media and misinformation. And the release of sensitive plans and financial data, obviously, the day before a stock is going to report its earnings. If employees went out on social media and said, hey, it's going to be a really down day for company B tomorrow because they missed earnings and revenue, you can imagine the manipulation of the stock. So companies certainly monitor for all those things and anything really that may impact the workplace, including things that you may say on social media that may have hate involved, right? You're entitled to your opinion. You're not entitled to preach hate, right? And we all know that. And so companies can monitor social media for those things. And it's a very slippery slope about whether or not they need to keep you if they disagree with things that you say. Certainly, they wouldn't want to target people for political leanings, although I'm sure that happens. But if it impacts the company and your political leanings are such that you detract from the image of the company, then they have a dog in the fight. And that's why they monitor social media. But there's a couple of good cases to look at in this as well. So one that I found kind of interesting was Shearer Design Group versus Ahead Engineering. And Shearer Design Group is a larger company, relatively speaking, and Ahead Engineering and Farfield Telecom were two companies that were formed by former employees of Shearer. They left the company and were having conversations via Facebook, private mode, with clients of Shearer to try to lure those clients over to their new companies, right? They took their skill set that they had with company A, the big company Shearer, and they used that to form their own companies, and they were talking to people on Facebook in private mode. Now, one of the employees, when the employees left Shearer, they had to leave their laptops, and it's disputed as to whether or not the person ever signed out of Facebook. From what I understand about Facebook, even though you may sign out, you have to go like one step farther to erase the history. Otherwise, you're technically still pseudo signed on. And the company was able to take the old laptop, fire it up, and open up Facebook, and they were in the guy's account, and they monitored it. The court really didn't make a judgment because there was an argument whether he had signed out, whether he hadn't. They really didn't get involved in that. But what they said was that it was perfectly acceptable to use the company's laptop to look at information that the employee left. And one of the things he apparently left was Facebook in an open status. And even they discussed about whether the company may have, if it wasn't open, did they come across his password somewhere, which is also stored somewhere in the history of any place you sign on to Facebook. Don't, make no mistake about it, that when you leave a company, your history stays there. And if you've used passwords, they are there. But they found that it was perfectly acceptable for the company to monitor former employees to make sure that they weren't harming the company using artifacts that the former employees left behind, that they failed to adequately close or protect. They used them while they were part of the company. The information was there. It became the company's information. Now, that was an interesting case for me because I get involved in that type of insider threat type cases. But let's just look at the general, social media, the guy who's out there on Facebook saying, man, this company really sucks. I hate my boss. He's this, he's that, and talks about the company in a bad way. And I will tell you that companies will fire people for that, right? And they often have rules where you must identify yourself as an employee before you say anything about the company, and you agree to those rules, right? When you come into the company, it's in the employee handbook, and you sign saying, I agree to the company handbook. We all sign those papers when we first get there. We're happy to have the job, and we'll sign anything. But the number one thing that we hear from people in these matters is, I have the First Amendment right to say this. Okay? The First Amendment reads, Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, blah, 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 blah. Congress shall make no law. Companies may make a policy. What you say on social media may be prohibited by your own company policy. And it is not First Amendment rights. The government cannot arrest you for saying things unless it's insightful or seditious. But a company can dismiss you for things you say on social media. Remember also that almost all employees in America today are at-will employees. And that means you can leave the employment of that person anytime you like. Anytime you like, you can say, I quit. And conversely, the company can say at any time, you are fired, with or without cause. Now, there are some things that you say on social media that are protected, that a company, even in an at-will employment, could not fire you for. And that's concerted activity under the National Labor Relations Act. What is concerted activity? So workers have the right to address work-related issues and share information about pay, benefits, and working conditions with coworkers on social media. Okay? You can't just gripe about some aspect of work. That's not concerted activity, right? You can't say, man, I hate my boss. Gosh, I wish this guy would use some mouthwash. I wish he would, get some neckties that were not 10 inches wide and made in the 70s. You can't just, assassinate people. This is concerted activity that is really geared toward the potential unionization or forming a collective in the workplace. So, the old saying used to be that employers would say, you can't discuss your pay with anyone. And you could get written up in the old days about, if you disclosed that you made $6 an hour to somebody else who made $5.50, because they saw it as being counterproductive in the workplace. The person who made less money then would produce less, would be sore about it. So if everybody's salary was secret, then no one could really know what anybody else is making. Everybody thinks they're making more than everybody, and everybody's happy, right? But the concept of concerted activity says that if employees want to talk about their pay and their benefits and their working conditions with coworkers, and they want to do it through social media or any other matter, they may do so. A company cannot limit those discussions because it is a matter of right, because those employees may want to talk about the idea of collective bargaining to make those conditions better. But if it's egregiously offensive or knowingly and deliberately false, then it is not protected. So you have to be very careful with employees' social media. When they say things that are against the company, you have to understand whether it is just egregious and false, whether it's true but not related to their working conditions, or whether it's related to working conditions, because that final one is a protected. So I thought you might find that stuff interesting only because it's stuff that affects every one of you no matter what you do. Right? If you go to work tonight, those laws do affect you, right? Whether your employer can put a GPS on your car, whether your employer can send you for a drug test, whether or not you may hop on social media, whether there are hidden cameras in your workplace, those laws affect you no matter what you do. But as a security manager, those are decisions you make as to whether you're going to use those tools and how you're going to use those tools. And so I think those laws and those court cases are important for you to know. Now, we're going to shift gears real quick, and I just want to talk very briefly about two security-specific administrative laws. The first one's the Customs and Trade Partnership Against Terrorism, and the second one is the Safety Act. There are tons more. But these two are very specific to security managers, and I can tell you that I could probably name 10 others that are, But these are two that if you have some knowledge of them when you go into the workplace in a corporate security environment, you're automatically bringing in some ideas that may help your employer. And when you can do that and you can communicate that even in an interview, it's going to make you a little more attractive. So let's talk about what CTPAT and the Safety Act are all about. So CTPAT is a voluntary program. A company volunteers to join and work together with Customs and Border Protection to protect the supply chain and identify security gaps in the supply chain and to implement specific best practices. So a company like the one I work for, we are CTPAT members, but it very well could be others that have cargo that they want Customs and Border Protection to help them protect. And so Customs and Border Protection, you voluntarily join CTPAT and you become a partner, and you have certain then obligations. Normally, they're considered low risk for terrorist activity, right? It doesn't mean your products are not valuable or not even valuable to a terrorist, but the companies themselves get a background check, if you will, to make sure that there are no ties to terrorism. So they're considered low risk. And when you join CTPAT, the things that you send to foreign countries are less likely to be highly scrutinized by customs. They know where they're coming from, and therefore they kind of go on a bit of a fast track. The CTPAT extends the zone of the U.S. border zone to the business point of origin. And by that I mean, if you have products that you want that are CTPAT certified, right? If you're CTPAT certified, you make your products in your factory. You keep them under your control. When they are finished, you put them into a secured area that is under certain control that Customs and Border Protection approve. It could be a cage of some kind. It could be under video surveillance. It could be an alarmed area. Could have guards on it, depending on what they tell you that you need to do to protect that product. When the product is ready to be shipped, it is picked up by a CTPAT certified carrier. FedEx, UPS all have CTPAT certified facilities and people, and they come and they've been screened properly, and they come and they pick it up and they take it directly to the airport or the port or wherever the point of disembarkment from the U.S. is. And it doesn't need to go into the customs house to be put in line behind everybody else's stuff. If it's been marked by CTPAT, if it's coming from a CTPAT certified facility, it's being carried by a certified CTPAT carrier, it gets to the airport, and if that pallet of drugs, in my case, right, medicines, is going to Guatemala, and there's a flight going out that's going to Guatemala or connecting to Guatemala, it can go directly onto the plane and not have to go through additional screening. They have extended the border zone to say that my factory is technically, that cage in my factory is part of the border zone. Anything that's already in that cage has already been inspected and approved for border. So it extends the border zone to the business point of origin. So what's in this for me? Well, there's a reduced number of examinations by customs, and I get to go to the front of the line on inspections when there are checks. There are stratified exams, of different types on different materials. Consider the airport, right? This is almost like a TSA pre-check, if you will, for products. It's a lot harder lift than just signing up for it and getting a background check and giving them your fingerprints, but it shortens the wait time at the border. I have access to fast lanes at the land borders, right? When you come in, we have trucks that come in from, they leave one of our facilities, let's say in Michigan, and they're on their way to Canada. When they get to the Canadian border, they are already identified as CTPAT partners. They go into a special lane and they get a quick check. Nobody's really going to crack the back of that truck open and put the dogs through it and run it through a big truck x-ray. They know that it's coming from a certified facility and a certified carrier, and through the lane you go. You don't have to wait in line. And this is recognized by some foreign governments as well, so you get reciprocal privileges. So we can do this when it arrives in country. If it's arriving from a CTPAT facility, oftentimes it's put in the front of the line to be released. And so that has some real business advantages, which is why I want you to understand CTPAT as an option as a security manager, because there's ways you can make this work for the business and be a bit of a hero. So I want you to think about it. If I don't have to wait at the border, and I don't have to wait to get my stuff on the plane like everybody else. And then when it gets in country, I don't have to wait to have it inspected again. I'm almost like Amazon Prime, right? My stuff is getting there before anybody else's. And if I have a competitor and we have someone who says, okay, I want to order just-in-time materials and I need them here, on a 3-day notice. If I have CTPAT and it's a foreign destination, I can probably do that. If I can produce it fast enough, I can probably get it there because I don't have to wait in a customs house. I will tell you that when you have materials that don't go through this process, I have sometimes materials that sit in Russian customs for months, Chinese customs for months. So it's an important competitive tool. You get much better service from logistics carriers. So FedEx spends FedEx Custom Critical to pick up this stuff with this special carrier. He can pick up 3-4 loads and deliver them to a port in the time that one truck normally has to go and sit in line at the port just to drop the load off and do all the paperwork. So logistics carriers love this. If they're picking up a CTPAT load, they know that they can get more loads out, which is more money for them in the course of a day. And you get a higher level of driver and handler and support because they've been background checked and they've been trained on what they need to do and to prevent terrorist activity, right? To identify it at least. And it gives you clear context within Customs and Border Protection, for anti-counterfeiting or items that are stalled. Like I was saying, I have some security components that were sent to China 3 months ago. And I just got them released, but they would have been there another year had we not had somebody at U.S. Customs finally, negotiate with the Chinese to release these parts. And they were parts for a security system, a protection system. So there's having the idea that security can impact the speed of delivery and thus potentially beat out the competition in materials that need to be delivered quick. That is an amazing tool for you to take into an employer to say, hey, if we did this and we've got all these foreign shipments, maybe we can get our stuff out of here faster. And maybe we need less storage space because we can get our stuff moved out of our warehouses quicker. There's a lot of ways that you can impact the bottom line when you use these programs. So think about CTPAT as a way for you to put a feather in your cap when you get to a new employer to say, I have a way that we can speed business up. In the same token, the Safety Act, which is Part 6 of the U.S. Code, it encourages the use of anti-terrorism products that are considered qualified anti-terrorism technologies. Basically, what it allows, if you have a product that is Safety Act certified, you can sell it to someone, and that person is protected as if they were a government contractor if there are claims that arise from acts of terrorism. So, for instance, blast protection. I buy blast protection for buildings. Just bought some for a building in New York City. And I make sure that it is a qualified anti-terrorism technology covered under the Safety Act, and it's a certified product. And if indeed, God forbid, there was a terrorist attack at the facility where I put it on, and people did get injured, my liability would be much less because I used a Safety Act product. There's only just so much you can do, right, to prevent terrorism. We know that. We look at terrorist activity around, and many of your Homeland Security majors, and you've seen the videos and you've read the articles, right? You understand that we can't prevent some of this stuff, but if we use the right products, we can mitigate some of the damage. And if we use products that are covered under the Safety Act and certified, first they get designated, right, as they're going through technology, and then they get certified. And there's a cheat sheet, if you will, or a fact sheet as part of the reading this week that'll explain that to you. But basically, it helps you protect your company from liability if indeed that product went bad. So let's take a look at some examples of that. So, Safety Act encourages the use of the anti-terrorism products that are qualified anti-terrorism technologies, and almost all of them are already in use by the government or the military, or they were developed for government use. So the government is assured that they've gone through proper testing with this stuff, and they're saying, look, as far as mitigating the risks and the effects of terrorism, this is as good as we can get it. And therefore, if you use those products, we'll make sure that we protect you from liability if something goes wrong. It's a lawsuit defense, really, okay? Because if these things are tested in a real terrorist attack, and some injuries will occur, right, as we know, the families, the lawsuits, those things, you have some defense to say I used qualified products here, and the government will help protect you. Now, the types of things: blast protection, like I said, certain sensors, screening services, weapons screening services. I have a product now that I'm looking at that is weapons detection. So it uses sonar, and when people walk through, instead of metal detection, it's using sonar to look for printing on the body of weapons that they may be carrying. And it is a certified Safety Act product. It is a qualified anti-terrorism technology under that act. And if indeed I use that product, and again, God forbid there was a shooting, someone got a gun in, they went through that scanner, but they got it in anyway, my liability would be much less because I have taken precautions against it with a qualified product. So when you're asked to use products, you should look for those that have a Safety Act certification. Not that they're better products, although I believe that they really are, but more so that not only is the product going to give you the use that you want out of it, but it's going to cut your liability automatically because it has that qualification. So here we are at the end again. We talked a little bit about privacy and, kind of carried on that conversation, but again, more so privacy in terms of what the employee should and could expect. And as a security manager, you must honor those things and understand those court cases and understand those decisions and administrative laws that impact the employee's privacy so that you respect it and you don't get jammed up by invading that privacy or violating their rights to privacy. You had the lecture. You've done it. Thank you very much. There's some reading. It's very light. It's really just a few explanations and again that fact sheet. There's a quiz this week, and yeah, I'm getting quizzed out too. I get it. But I try to alternate this class and my last one, and my other class this semester is the physical security that some of you in, and there's a fair amount of design work that takes a long time to go over, and it's new to many of the students in that class. If you've taken it before, we're designing the warehouse project, and so I apologize, but I think we only have one more quiz after this one for the remainder of the semester. All the teams have set their times and dates, and I'll put out something in the news with those to verify, to make sure everybody understands the commitment they've made to week 14. And I will be sending out some information to your team leads this week on what to expect in those meetings so that they can send it on to you, and you guys can make plans as to how you want to attack that work, that 1 hour of quality time with me and what you can expect, and maybe you want to do a little organization beforehand. So with that, everybody have a great week. If you have questions, if you have concerns, you know where to find me. Please don't be afraid to reach out. I know many of you do. Some of you I don't hear from much, but please, if you have questions, concerns, anything you want to talk about, please just reach out, text me, email me, and I'll get right back with you. Have a great week.